Hello, and welcome to our periodic webinar series at the Syracuse University Technology Commercialization Law Center and the Syracuse Intellectual Property Law Institute. This is Professor Shubha Ghosh at Syracuse University College of Law, and I'm very pleased to introduce David Hrycik, who is a professor of law at Mercer Law School. He presented for us before in the area of professional responsibility and patents. And today he's going to speak on ethics and emerging technology, artificial intelligence, Internet of Things, and 3D printing. So welcome, Professor Hrycik, and thank you for doing this for us again.
Well, thank you. I'm really glad to be here, and I'm excited to be here. And to me, this is one of the more interesting ethics talks that I give. And let me tell you just a tiny bit of background, and then I'll tell you what I'm going to talk about, and then start talking. Few years ago, Vanderbilt Law School asked me to come up and talk about this topic in a very generalized sense. And in part of that, I really began to dig into how technology was changing. I mean, we're all aware of it to some extent, but just the rapid pace of change. And as I dug further into it and talked to people and did more and more research, I began to realize that there were a number of things combining to probably, I think perhaps not more than probably, but likely going to change patent practice and the value of patents and the utility of patents greatly. And the result of that became a paper that they published a few years ago, and then other papers and talks since then. And this is the culmination of that, is kind of trying to pull together the ethical issues that are created by emerging technology, artificial intelligence, Internet of Things, and 3D printing. And this, I will tell you each time, what I will try to do is to talk about practical things. I'm going to talk about some pretty theoretical stuff and some technology and some gee whiz sort of things. But I'm also going to each time try to bring it down to the level of what can you do about this. Now, there are distinct things that you should consider if you're a practitioner in this area. And the first is, must you or must you not use AI drafting aids? And there's a definitional issue about what is artificial intelligence, and I'll talk briefly about that, but I'm using it in a very broad sense, and we'll take a look at even some mundane things that you could quibble aren't AI, but not my thing to try to define it carefully here, because I don't think there is a really good, useful definition. But it's important to look at, you might have an obligation to use these things, and we'll talk about the ethical rules about that, or you may have to avoid using them depending on your due diligence, and I'll talk briefly about that. The other thing that's a very fundamental thing is, are patent laws able to deal with AI as an inventor? There's already been a case in both, a patent application in both the US, the UK IPO, and also in the EPO, addressing whether somebody other than a real human being can be named as an inventor. What did they, we'll talk about what those patent offices have said, and what can you do to avoid the problems. Then another related issue is, are patent laws sufficiently open to patenting AI-based inventions, and what can you do now to increase the odds of eligibility? In other words, what if you're seeking to patent something that is an AI-based invention? This obviously implicates Section 101. We'll talk about the PTO guidance and how it can help you to prosecute applications successfully, but also how you can use AI to enhance the ability to ensure issuance of an application, kind of use the AI against itself, if you will. This is where it, to me, gets really interesting. And in talking with folks, I think I've spotted something, and that is the patent system fast enough, given the increase in innovation and its speed? And there's two sides to that, right? There's the side that innovation's occurring more quickly, but there's also the side that once a copier, an infringer, sees a product, it's easier and quicker for them to get a product to market. So what can you do to maybe slow down competitors or speed things up as far as patent prosecution goes? Because speed is becoming more and more important. I'll talk kind of briefly, but a bit about 3D patents. Do the patent laws adequately protect against infringement? And I'll show you some silly examples of stuff that you can 3D print that implicate patent rights, but also trademark. And I think there's one example of a copyright thing. What can you do to help protect your clients against 3D printers? And I'll talk about what I've seen practitioners do, but also just some sort of, hey, think about this. Okay, so this first topic is dealing with the question of must you use these technologies or not? And this gets me into the ethics. This is a bit of an ethics talk, and so I got to mention them a little bit. All states require that you be competent. All states require that you use reasonable care to protect client confidences. Some states have very specific rules addressing technology as such. Not all of them, but I don't think this matters. In other words, if you have a rule that says you have to use to be competent, that includes technology. You don't have to have a specific rule that says you need to use technology competently. I don't think you have to have a specific rule about using reasonable care with the confidentiality when if you don't have a rule specific to technology. If you have a general rule, use reasonable care in protecting client confidences, that's going to include when you use technology. But the model rules and some state rules have specific requirements relating to technology. Now, the PTO does not yet have comments to the rules, but they do have the model rules in place. So here's the comment, and this is in the Texas rules in one place, it's in some state rules in other places. But look what it says: lawyers must keep abreast of changes in the law and its practice, including the benefits and risk associated with relevant technology. Notice what it's saying is you got to think about it, the good and the bad of using it. And obviously that's where it gets into, must I use this? Must I not use it? The model rules have a specific rule about using confidential or protecting confidential information and technology. This is in Rule 1.6C. And again, some states have this. It says a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. If I am using AI to do something, I have to provide, obviously, AI with information relating to the representation of my client. I'm going to show you this gee whiz thing of a AI-based patent drafting system. To use it, I had to, it wasn't my client, it was something I found on the internet, but I had to give it a claim. Well, that claim language was obviously confidential information that I provided to this system somewhere out there on the internet. We'll talk about what you have to do to make sure you comply with your ethical obligations anytime. If you're storing information on the cloud, but anytime you're using client information, and particularly if you're giving it to a third party to use in a process. And I'll mention some terms of service to look for. As another example of the importance of technology, there are now 2 states that require text-specific CLE. I know Florida is one of them, and I can't remember off the top of my head which one is the other. So as of now, no court has yet said that for purposes of like malpractice, that you have to use AI, but competency may require that you use a particular service in a matter if it's ethical to use it. And let me give you a real mundane example, right? When I was a baby lawyer, I used what was called Shepherds, and they were these books, and there was a red one that was like vinyl on the cover, and then there was a red paper one, and there was a yellow paper one, and there was like a pocket part. And you had to go look up every case you were going to cite in a brief and see if it was up to date. Well, nowadays, you go on Westlaw or Lexis, whatever you're using, and you push a button and it instantly tells you, and it gives you more information than West would have, or Shepherds would have been back then. I don't think it would be ethical to use that paper version of Shepherds, given that we have this technology that gives us better information, more updated information more quickly. Now, that is probably a form of artificial intelligence. I doubt people are still coding that stuff at West. So that'd be an example of where I feel pretty confident that it would be wrong for me to use that old method instead of this technology. Now, granted, I never have bothered to do a lot of due diligence into it. I just trust the brand name of West or Lexis to have gotten that right. And that's a simple example, but that kind of makes this point. So to use or not to use, that's the first question we have to think about. And these are examples of stuff that's out there. I've used, like I said, I've used Keysight and Instasight, which are the modern versions of Shepherds, to do legal research. I think everybody uses those nowadays. I've not used Dagger Analytics, but that seemed to be one of the leading programs for doing predictive coding, which is used in ESI to figure out which documents are likely going to be responsive or privileged or other things. I don't think in a large discovery case that it would be proper to look at everything by hand anymore, because we have technology that it seems like does it just as well, if not better, than that. There are some things that I use a little bit and I don't know a lot about. I've used Lex Machina some. You can get good analytics about patent suits and other things on there. This stuff, I mean, think about it. If I can use that to get a good prediction of whether a judge is going to grant a 101 motion or not, do I have to use that because I can give my client better information about whether we're likely going to succeed on this 101 motion before we spend $50,000 writing it up? You know, I don't know the answer to that. No court has yet said you have to, but you know, clients might want that information, and it may be someday a court will say, why didn't you do that first before you blew all this money on this 101 motion? Again, not anytime likely soon, but it could. There's some stuff out there I've only read about. Thankfully, I don't do contract drafting, but there are programs, and I'll mention one of them in a moment they ran a test using it, where they look at contracts. So this is like, you know, Intel or Texas Instruments or something, or Dell, I guess would be a good modern example, where they have 10,000 of the same contracts. You don't want to have a human being look at 10,000 of the same things over and over again. But what this does is it looks for ones that have contracts that have different language, and it spits them out and says, okay, a person needs to look at this because it's got something different in it than all these other contracts. Is it ethical? Is it competent to rely on people to do that? Hold on a second, and I'll show you an example where I think the suggestion is that maybe not. There's even now services, this is kind of scary for those of us who like create things and we think we're special. There's Ross Intelligence does basic brief writing. Now, from what I can tell, basic is the emphasis I'd give there, but it does a rough first draft of writing a brief. And you tell it kind of what your argument is, and it pulls it all together. There's contract drafting services. This LawGeeks program supposedly drafts contracts using models that you have filtered into it. These are all examples, and the Specifio one is the one I'll talk about the most because it's most pertinent to patent practice. It actually writes patent applications. Now, it scared the heck out of me when I used it now, and I'll show you the example of what it wrote. And it creates a lot of issues for practitioners. Now, fortunately, right now it is limited to software patents. I think he's the owner, and I'll talk a little bit about that, is going to expand it, or maybe he has expanded it some. But it's scary what it can already do. And I will show you the language that it created, and I'll say that it invented something, and we'll talk about the repercussions of that.
David, one quick question. You may get to this, but I think it's worth raising here. What duty do you have to your client to disclose that you're using these technologies? I mean, your clients might have certain expectations about maybe even using Shepherds, or they might have some. So
I hope we don't have to disclose that we're using Shepherds.
Yeah, no, I understand, but I guess it might be relevant as far as allocating the risk and so forth if the technology gets something wrong in terms of, you know, related question to the disclosure that arises.
Yeah, and the ABA there's an opinion. If you think about it, what you're doing is outsourcing. You know, you're taking with Shepherds. I mean, instead of doing it yourself, you're outsourcing it to a computer. Right. And the ABA has an opinion about outsourcing, and it gives this guidance. It says you may need to tell your client about it.
Okay. Right.
So, you know, and some of these things, like Shepherds, I mean, we're not going to have InstaSite, whatever it's called nowadays. You're not going to have to tell your client that.
Right. Of course. Yeah.
You get into some issues though about a contract review program where I think you need to be clear to your client about where the charges are coming from. You obviously can't charge lawyer time when you're having a machine do it. But also there are some things where I would want to let my client know, you know, I'm providing your information, this claim, you know, that you want me to write the application for, I'm giving it to a third party. The reason why I think a client might want to know is what if that claim happens to be on their, you know, next big iPhone, whatever it is that they are, you know, coming out with. They may be nervous about sharing it with a provider. But I'll also show you the things that you can do to look at to make sure that if the service works, then, you know, what are the terms of service about it? What kind of due diligence do you need to do to make sure that it's proper if it does work for you to have your client use it?
Yeah.
But it's a good question. I'll kind of get to some of that in a little bit. So look, this is from 2019, what the ABA said, and this relates to this idea of, okay, if it works, then I need to think about, because if it doesn't work, let me be clear, if it doesn't work, then you can't use it because it's not
Right.
providing competent legal services. But the ABA said you have a duty to identify technology that's needed to effectively represent the client. And look at what it said further, as well as determine if the use of such technology will improve the service to the client. So you need to ask yourself, can this machine do it better than I can?
Hmm.
And if so, the pros and cons of that, because there are cons, because it is out of your control and you are relying on some third party. But look at this. And when I get to the patent application drafting thing, you'll see another example. They
Hmm.
ran this experiment, and this wasn't the company's experiment. This was an actual neutral third party. Let's see how this thing works.
Hmm.
They used this LawGeek service to review a non-disclosure agreement to see if it had any problems. Look, and then a whole bunch of this NDA and a bunch of contracts. The lawyers took 92 minutes to review it. LawGeeks took 26 seconds, and it was more accurate.
Hmm.
Okay, so that's an example. It's more accurate and it's way faster. Now, what's the cost of doing it? I honestly, I don't know, but that's the other part of that calculation. And if think about it for a second, if I'm in a situation where I have a service that can do something in a minute and do it better, and then an hour and a half of my time, I got to look at that cost issue and really think about, is this in the best interest of my client? The other thing about that, and I'll come back this at the very end of this, is I think, need to be thinking about my young lawyers. Part of the learning process as a young lawyer is doing that work. And if
Right.
that work is getting pulled away, what's going to happen to the level of service that those young lawyers are going to be able to provide when they're medium age lawyers, or,
Hmm.
well, what's the right word? Riper lawyers. I'm not sure what
More mature. Yeah.
more mature. There we
Yeah.
go. I
Yeah.
like
Yeah.
that better than
Yeah.
riper.
More seasoned. Yeah, I guess.
More
Yeah.
seasoned. Okay, there we
Yeah.
go. So now this is to me is the craziest part of this whole thing. So about 2 years ago, to see how well it worked, I used this patent drafting service. And let me tell you the
Mm.
story behind this. So then this is part of this does this service work thing. So somebody told me about this, and I remember thinking, yeah, right. It's gonna be a bunch of garbage. I mean, that really was my reaction going in, and that also I wish I hadn't had that reaction, because I would have done things a little bit differently. I should ask the guy who let me use it to try it again. So I wrote a blog post on Patentlio, and I said, hey, there's a service that supposedly writes patent applications. I'm not a registered practitioner. I don't want to write a patent application. But I looked at the terms of service, they were like amazing. I mean, they were everything except like one or two little things had been thought of and
Hmm.
brilliantly covered. And so I wrote a blog post, and then Ian Schick, the guy who, I don't know if he owns it, but one of the people who started the thing, he emailed me and he said, oh, well, here's what I did. I wanted to do this service, and he's got like a linguistic expert and a computer science expert, and he's a lawyer, patent lawyer. So what I did is I said to some fancy California law firm, have your guys write terms of service that they would agree to before they would let their clients use the service. And I'm like, well, that explains why they're so good, because they were really good. So he said, well, why don't you try it out? And I said, well, I'm not a patent lawyer, but that'd be fun, So he gave me a free code or something to just try.
Hmm.
So I'm sitting there, and I'm like, well, how am I going to do this? Because it's a software patent application service, or it was then. I think it still is. So I thought, well, I'll find some published claim, because you have to submit a claim and it writes the spec. So
Right.
I found some published application, and this is where I wish I'd spent more time. I wish I'd really focused and thought this is a good one to use. Instead, the first thing I found, I copied the claim from it, and um, I think you emailed a Word document, I think, or maybe there was a box on the internet and you press send. I don't remember now. So here's what I did, and then here's what it invented. So this is what I submitted. And again, I copied this from some published application somewhere. I don't have a clue. I mean, I know sort of what this is, but it says a system configured for routing communications in a computer network, the system comprising one or more, hardware, look, the little boxes on top of that, hardware processors configured by a machine readable instruction for, and it has a bunch of things. Now, the only thing I think I did is I put in the numbers. I think I had to put the numbers in for it to recognize the steps or something like that.
Mm-hmm.
So this is some kind of way that computers talk to each other over a network. So I submitted that, and literally this is how this happened. I thought, okay, I'm going to submit this. I'm going to get a bunch of garbage back. And I turned away from my computer, and about 15 seconds later, I heard a ding from my email saying, you got email. And there was an email from Specifio. And I thought, oh, it's going to be, thank you, we'll get back to you. Instead, there was a Word document and there was a PowerPoint document. And I clicked on them, and this is what I saw. Okay. Now, this first part, you're like, yeah, whatever. System and methods. So it pulled the title somehow. Field of disclosure. So it pulled a little bit of language. And then it has, some boilerplate stuff. But now I want to call your attention to that little number 114 there. That's how you refer to figures. So
Right.
hold that thought. So now, and this is in English. This is what I got back within 15 seconds. One aspect of the present disclosure relates to system configured for routing. The system may include one or more hardware processors. The processors may be configured. This is actually in coherent English. I mean, it's actually readable. It actually has subject-verb agreement for the most part. There's some little things. But now, and I'm not going to read all this, Look at this detailed description. Figure 1 illustrates a system 100 configured for routing communications computer network, Servers may be configured by machine readable instructions. Yeah, 15 seconds of
Wow.
code. Yeah.
Wow.
Yeah, I know. and so then this came, and I did not actually, I saw the PowerPoint thing. I thought, what is that? It drew a figure, a flow chart and a figure, and has all the little numbers and the diagrams that correspond with, the text. And it actually, I mean, I did not do any of this, and I could not do any of this. I mean, I probably could if I spent 100 hours trying to do this. This machine drafted a spec in 15 seconds that I wouldn't have tried to do this, but it would have taken a lawyer some time. When I asked Ian about this thing, he said he uses it to draft his own patent applications for his company, or his company's Specifio, or whatever the company behind it is. And he said the cool thing about it is one of the cool things is he went from writing 1 application or so per day to writing 8 applications per day. And he went from having to focus in on writing all that fairly mundane language in the spec to focusing in on the claim and then polishing the spec. And the thing that he thought was really wonderful about it was, if he gave 8 applications to 8 associates, when they came back, each one would have its own little foibles. The author would have had his weirdness one way, another author weirdness the other way, weirdness from the perspective of Ian.
Right.
This
Idiosyncrasies,
way, yeah, this way, each one had its own idiosyncrasies, but exactly the same way. So if he didn't like the word herein, he would know I've got to search for herein and get rid of it.
Yeah.
And
Yeah.
he said it just, the consistency of it had value alone to him. But to go from 1 application to 8 applications and give yourself more time to focus in on claim drafting, which is I don't know if fun's the right word, but the part of that is creative, is extraordinary. And so what do you do, if you can use this, if it works, and I have no idea if that's a good application or not. I wish I'd spent more time picking out one where I looked at the spec and I appraised the spec, and instead I just randomly picked one because I wasn't. I honestly was predicting it was going to be garbage. I mean, I just was like, sure, whatever, and then I got that back, and I was like, and I'll tell you, I didn't focus on this. It wrote another claim. It added another claim to the one that I wrote. And there's a blog post I did on Patentlio today about who's the inventor of that? And I'll talk a little bit more about that just briefly in a second. But so if that works, and again, nobody should ever take a spec written by a computer or written by a first-year associate and just submit it. I mean, obviously you need to review it. But if it does work, you've really got to read the terms of service carefully. To show you how boring my life is, I went around and I read a bunch of terms of service, and there are some really horrible ones out there on services that lawyers use. If you look at the ones for Specifio, they are really well done. they cover things that what are we going to do with client information? They use a system where they strip out anything that is an identifiable word and put in a bunch of gobbledygook, so they don't get cross-pollination of one customer's application and another's. They don't disclose information unless there's a subpoena, and they give you notice and those sort of things. So
Yeah.
it's really, really well thought through. This is another important thing, and this is, if I remember right, was what I thought was missing, is there was no assignment of whatever rights the AI provider might have to your client. I mean, copyright would be the obvious thing. They wrote the spec, and so there better be an assignment of whatever copyright ownership rights they have to your client. The same thing is true is if they can be an inventor, you want to make sure whatever rights they have, if any, are assigned to your client, because you might have a problem with who owns the invention. But those things should be covered, and I wrote this article, again, this I think is the Vanderbilt one, which just focuses in on a lot of the other ethical issues about using these augmented drafting services. And if you can't find it, email me and I'll send you a copy of it, because I'm sure I have it somewhere. So,
For one quick question from Ian, did you have so you talked about the 8-to-1 ratio for the patent applications. Did he have a sense about how successful those 8 applications were? I mean, did he find a better success rate, or is that too early to gauge?
I didn't ask him. I did not ask him that, but I know he felt very comfortable with what he was getting out of them. And again, it's remarkable. Maybe this is one of those things where technology is going like this, and I learned that I am here and it was going like this. But I don't think, given what he said to me, I don't think he would have used it if he was getting bad results. But like you said,
I'm sure. Yeah.
But like you say, with the lag of application time, who's to know? But the other thing, though, I remember him saying was it's just the ease of editing them or whatever, revising them, knowing that they would have the same idiosyncrasies or problems each time, as opposed to 8 different associates writing those applications. That was a money saver and time saver was enormous.
Right. One thing I was wondering too, this is maybe more of a more advanced topic, is this, we talk about tacit knowledge. You don't necessarily put everything in the specification. I wonder if something like, if this sort of catches on, what happens to the notion of AI tacit knowledge,
Supposedly it learns.
Interesting.
Yeah, and and again, at the start, I bet you that its level of expertise was a little bit low, but one of the things that you give permission for it to do is to use your spec to learn to write better specs. I assume it's part of, now again, they strip out and they put in, just gobbledygook letters and numbers for keywords. So I'm trying to remember the example. So instead of saying a slave network, it would say XYZ7 network. So it would strip out those things so they don't get misused, but it used enough of the boilerplate words or plain English words, whatever the rote words, whatever the right word is, so that it could learn as people provided more information.
Interesting.
Yeah, no, it's just fascinating. And the collectivity or the collective wisdom needed to make that work, of having a lawyer, linguistic expert, and a computer PhD put that together, to me, it was also a remarkable backstory to it.
And I guess down the road, when we talk about patent litigation, whether you can depose AI is going to be an interesting question.
Good Lord. Yeah, that's a fun one there. I'm trying to think too. Could you imagine you want to see the data set that was used? And I mean, good Lord, I'm glad I'm getting out of the business pretty soon. What's interesting is and I noticed I changed it from what if and to what to do when AI invents things. There's an application I mentioned, and I'll talk about in a second, that I think it's pronounced Dabus, D-A-B-U-S. It was allegedly, or at least it's represented to those patent offices, this Dabus thing created these patents, created these inventions. And the PTO and the UK IPO office and or IP office and the EPO were all faced with the question of whether a machine could be an inventor. And I'll talk more about that in a second. But right now, what is happening, we've got answers from them, and they all said no. But there are working groups in all these organizations that are really struggling with this stuff. And let me give you that one, but also some others which are really, kind of scary when you think about it. Will everything be obvious or lack an inventive step, right? Because think about it, the idea of obviousness is, you imagine the person of ordinary skill in the art who knows everything in the art and would have been obvious to him. Well, the machine invented it, and the machine knew everything in the prior art, so it was obvious because the machine came up with it. That's
Yeah.
the argument that's made. And so our hypothetical person now exists, if you want to think of it that way. And what do we do about that? And some people are suggesting we need to have an obvious for a human standard for people applications, and otherwise maybe nothing you and I can come up with will be patentable.
Yeah.
There's another suggestion that says, what if you limit AI to what a human being could rationally remember? I'm not sure how we get that accomplished, but that might be a way to keep in the idea that we're trying to reward human activity here. But they're struggling with those issues, and there are working groups in all these organizations. The other thing I was thinking about is you've got to make disclosure for enablement. And then a couple slides in, there's a claim the Patent Office did for facial recognition technology. I assume that there's this huge data set that goes into enabling this software to recognize faces. Do you have to disclose the underlying data set? How do you do that in a patent application? So do you list it on an IDS? How do you disclose what the machine thought of as prior art when it thought of, who knows what it thought of in the data set that you provided to it, or maybe it scoured the internet for things. So there's a lot of what do we do about this power? And then this part here about what if the AI invented something? Who is the inventor? Is it the person who collected the data that went in, who chose the data, who created the algorithm? Is it some of those people? Is it none of those people? What if there's a company that owns the software, another one? We think of inventors as being people, and that is in fact what the statute says. It says person, and that has answered the question for now, but I think all we've done is punted the question down the road by relying on a statute, which I get. Statute says person, and so you have to have a person. But they're really struggling with these issues because these issues are live today. What do you do if a machine conceives of something? Obviously, well, I was gonna say, obviously it doesn't build it, but 3D printers might do everything by the time we get there. So this is the USPTO's decision. They had this DABUS application was filed in the US, and the application did not list a human being as an inventor. And so the PTO issued a missing parts notice, which is when you don't have everything you need to have for a patent application. And they said, you need to have an oath or identifying who the inventor is. And the applicant wrote back and said, the DABUS, this thing DABUS is an inventor, and it says this DABUS thing is a creativity machine. And so it created this, it invented this. So USPTO files this notice of missing parts saying you need to list inventor by his or her legal name, and you haven't done it because DABUS is a thing or a it. The applicant says, I want the SPIE to get involved, get some kind of reconsideration here. And then what happened was, and this is interesting, in May 2020, the PTO actually published a decision on this petition denying reconsideration, holding that under the plain text of the Patent Act, only natural persons could be inventors. Okay, that's great. That's great. But this is the key part of, I think the key part of what they said, because it leaves me with, so what do I do? Here's what they said. This is from the petition. It says the petition argues that the December 2019 petition presents a line of reasoning that suggests that reference statutes are intended to compel an applicant to name a natural person even when the person does not meet the inventorship criteria. So he's saying there isn't a person who invented this. So you're trying to make me put myself on there, and I'm not an inventor. I didn't do that. But it says, however, petitioner misunderstands the petition. The petition decision of December explains that 100F defines a term inventor as the individual who invented or discovered the subject matter of the invention. Identifying a natural person who did not invent or discover the subject matter of the invention as the inventor would be in conflict. Accordingly, the petition does not suggest you are compelled to list a natural person as the inventor who does not meet the inventorship criteria. So what do? I didn't invent it. A machine invented it. You say I can't list the machine. So what do I do? And that's where the PTO story ends. You can't list, they're making it clear, do not list yourself if you didn't invent it. But no,
Mhm.
you cannot list a computer. And so again, I'll use me as the example. And again, I didn't invent anything in that application I sent to Specifio. But what if, and this is, I was trying to think through, this would be the way this would happen. Suppose I have, it ends up with 2 claims in that. Let's say I did invent one of those claims, because I did write something I sent there. Again, I didn't invent it, somebody else did. But then in the second claim, Specifio writes, and then the PTO issues a restriction requirement. So I stay on the one and we forget about that. There's now an application that nobody invented, but it
Mhm.
discloses something, let's assuming new, useful, and non-obvious. What do we do at that point? I cannot list myself. That would be misjoinder of an inventor. What do I do? And right now, that's where things sit.
Yeah.
So right now, there's no way to protect these inventions, at least as I see it. And this gets, back to it. I can't name AI. If I didn't invent, and I said whatever's in the specification, whatever is claimed, obviously, in the second claim. So what do I do? And especially when the EPO and the UK office took the same position as the PTO did on this application.
Mhm.
I just think you're in a place where you don't have an answer. You can't list yourself as the inventor when you didn't invent. You can't list the machine because it's not a person. Here we sit.
Yeah.
And that's why these folks are struggling with what do we do, because we are here now. This is now happening.
Right.
Isn't that crazy?
Yeah. So as you suggested, the various patent offices probably, and ultimately the legislature needs to think about changing the definition of inventor. I mean, or just simply maybe create a different patent system or another IP system for creations by non-humans, whatever it might be. Yeah.
Isn't that scary though? I mean, so and I don't know how far off this is, but what if we end up a place where we need a good enough for humans 103? I mean, it sounds sad to say, but if you think of the computing power and the data usage power that these machines now have access to, everything. I mean, let me run it to its logical end. There's nothing that's patentable, because if you get to the large enough data sets or large enough access, everything is obvious because they can see everything, and we know everything builds off of what is the past. I guess you could still have some remarkably surprising thing, a chemical reaction that nobody thought would happen, and it happens, and so that is patentable. But other than that, there's not going to be a lot left for innovation in the sense that we think of it in terms of patenting. Now, again,
Yeah. Yeah.
that could be 50 years from now, and somebody else's problem, not yours or I. Or
Right.
mine.
Right.
So, what do you do? I'm sorry. Do you have a question?
Well, no, I was just wondering if a lot of the inventions are going to go more towards the applied side. So how good are these AI inventors as coming up with like really good human inventions? I mean, human applications, if they
And
don't know, all the
yeah,
things that humans actually have to do. But that might be more of a utility model system of the patent system rather than the traditional patent system. So
yeah, and I don't know if we have. I mean, right now, and I didn't look at what the Davis thing invented. It may be a new way to cook hamburgers that we would all love to use, or
hmm
maybe something that's completely useless.
yeah,
But if I'm designing these systems, I want to design them to make things that will turn into products or services that people will use. And
right,
so
right.
that's going to drive it towards, real useful things. I mean, I would think the market itself would.
I mean, I don't know the answer to this. I wonder about, for example, in the pharmaceutical area, we've been using things like proteomics or using not so much AI, but I mean, a computer-assisted design
And
in
and
that
that's that
area.
blurry line. Yeah,
Yeah,
that's that
right.
blurry line. You could argue, and there's people written papers about what AI is and is not, and machine learning
Yeah,
versus,
yeah,
and I just don't know. To me, what is it? Arthur C. Clarke that says any technology that's
right.
sufficiently advanced looks like magic.
Looks like magic. Yeah, yeah.
Yeah. What I mean, when I pressed that button and that thing came back 15 seconds later, that looks like magic to me. And it drew a picture of something that I guess I had described in that claim that I could not have drawn. I mean, that looks like magic to me. And
hmm
So I don't know. We're in a very strange place in terms of the speed of the
Yeah,
technology.
right.
But it's a fascinating place to be, though.
Yeah, it's fascinating. I guess I'm trying to be a bit less pessimistic by saying we really don't know what these machines are coming up with in terms of,
The-
ultimate patentability. I mean, it still might be the case that human beings will come up with inventions that actually, you know,
Have you watched Terminator?
yes, yeah, okay, right,
It doesn't end well.
yeah, true enough.
No, no. I mean, and I don't know, and it may be that the limitations of machine capabilities right now will are limitations that will leave some room for us. The other thing though too is I don't know. I mean, again, I don't know that the machines have the insight into what we need as people. What let's I mean face it, some of the needs that human beings have that result in patents are completely irrational. I would think computers are going to
Right,
be thinking of rational solutions. I have a
right.
my microphone is this Yeti Blue microphone, and I think
Hmm.
part of its popularity is its appearance. I don't
Right.
know if the machine can capture the aesthetic that it presents. I don't know why people like them or I like them or why I bought it, but
Yeah.
I don't know. We may find out. Maybe we may find out sooner than we would think.
Yeah.
This is the next issue, but it is kind of related to it. Is what if you're pursuing applications on AI-based inventions? And again, I hate to keep using Specifio, but it's the one I know about,
Hmm.
and I'm sure the other folks are doing it too. If you're patenting in the software area and it's whatever an AI-based invention means, you're going to run into 101 issues. And I went and looked, and the U.S. and China are far ahead for obvious reasons. They're also larger recipient countries anyway, receiving countries anyway, in
Right.
terms of applications that broadly fit within this area. And obviously, the big problem in this area is going to be 101 because you're dealing with something that's doing something on a computer, and that's immediately going to implicate Section 101. The PTO came out with these guidelines, I guess a year and a half ago, which help. China, from what I could tell, just by reading about it, seems like it is more open to patenting software inventions, good or bad. Not saying, but just seem more open. The EPO seemed sort of in line with the U.S. Again, just as a general matter. Um, what do you do if you're seeking to patent an AI invention? This is the PTO's guidance where they're trying to give people a roadmap. And I'm not going to dwell too much on the language itself, but this is the claim I mentioned earlier that focuses on a facial recognition technology. But what
Yeah.
the PTO said in its guidance, and my first comment was think of the disclosure you would need to get this, talks about different training sets of data, and just think of the amount of data underneath that and the disclosure that you would need to support that. But what the PTO said to do was be sure you emphasize in the spec technical, practical applications of the invention.
Hmm.
Because it's more likely the examiner is going to see this as rooted in reality and not as a I'm doing this but on the computer sort of thing. I hope the guidelines have helped. The other thing that you can do if you're prosecuting in this area is use AI against it. Use AI to avoid anti-AI groups. Uh,
Hmm.
this is this is an example of data. I forget where I pulled this off of. Uh, I don't even remember now what service I used. But what this was looking at 101 rejections by different art groups over time. And
Hmm.
so if you were smart, you could draft your claim or draft the spec in a way you would influence which art group it went to or which technology center it went to. So maybe reduce the likelihood of a one-on-one rejection. Because as you can see from this, there's great disparity among the art groups. So you might be able to influence where you land and then might be able to reduce the chance of a one-on-one rejection. The other thing though, and I said, don't be stupid, and this is just an anecdote, but again, ethics here. Uh, Somebody at the PTO a couple years ago told me that here's what had happened. And there's these services where you can get even more detailed information about an individual examiner.
Hmm.
So you can find out how long examiner Smith typically, the delay is until you get your first office action, or you can find out how often they abandon a case when you file your appeal brief, whatever statistic you're looking for. Yay, good. Find that out. Tell your client, we got a good examiner, we got a bad examiner. A practitioner showed up to an office interview and brought the data with him and said to the examiner, look, you reject things way more than other people, and you take far longer to issue your office actions. And the I forget, I honestly don't remember who brought this to my attention from the patent office, but they were asking me, is this an ethics violation? Because you have somebody trying to influence prosecution by something other than on the merits. And so use this data, but don't be stupid and do something like that. And I also don't think it's real, if I'm an examiner and you say, you're slow and mean, I'm not sure I'm going to say, well, gee, I really would like to help you today. I might say,
Right,
yeah,
right.
So this is great stuff. That technology, that information that you can get about examiners is wonderful stuff, but don't be stupid about it.
Mhm.
Yeah, I love that thing. So now, what else can you do? And this is where this gets into the next part of this about patenting and whether it's a really as good of a thing anymore. Remember, you've really got not a lot of predictability. You've got to let your client know that you've got not a lot of judicial decisions. Unfortunately, with the federal circuit, it does turn on panels a lot. If you get the wrong panel, you're more likely to get a bad result. Obviously, the claim matters the most, but the panel makeup can have a big impact. I clerked up there a few years ago, and I knew it as a lawyer, but it became clearer to me as a clerk that the panel choice makes a big difference.
Mhm.
The other thing is really sit down with the client if you're dealing with the 101 vulnerable area and explain the risk to them. And it's not just this, it is the fact of how patents have become less valuable over time. If you lay out all the Supreme Court cases from the last 20 years, all but like one or two of them are negative against the usefulness of patents. The other thing, and this is the bridging to the next part, is your client may or may not be in this area yet, but it's becoming a broader area of markets, is the time to market for products, the time on the market as well as the time to market are getting shorter. So products are coming more quickly. Because other products come more quickly, the life cycle goes down. And,
Right.
there's a lot of marketing buzz around this. From our perspective, I mean, it's great. We got more innovation, we got more GWiz things coming up more quickly, and we get a new one more quickly. But what that means is that we got to think about, is the system of patenting fast enough when what we have is faster innovation, products come and go more quickly, but also the infringer can get on more quickly. And then let me focus in on the time frame a little bit and some of the other things that are influencing this. Within it, the Internet of Things, we're getting real-time data on how products perform, drug efficacy, defects, things like that. My favorite example of this is there was a manufacturer of bicycle frames, fancy bicycle frames, not routine bicycle frames.
Right.
And what they did is they put little sensors on the frame, and in real time, it would report back. I don't know if they did it by Bluetooth when the owner got back, but they'd get back data, that this frame was vibrating if they were going this speed, or, this problem was developing, and they would improve their frames almost automatically using 3D printers. They'd be printing them using titanium or whatever it is they use nowadays for bicycle frames. So notice they're improving their product all of the time and making changes all of the time to those frames. How are they able to do that? They got AI, and it's able to look at all these data from all these bicycle frames and eliminate the noise. And this is the phrase I love. It says we can pull out real world useful information from all that, data that we are getting about our bicycle frames, and figure out, oh, we need to put more titanium here or less here, or change the shape, whatever it is you do with bicycle frames to make them better. So that is happening fast. And together, those two things, getting this data back right away and being able to process it more quickly into stuff we can change right away, is meaning there's shorter time to market for new products and shorter life cycles. And if you go look, it's really interesting. And there's a lot of stuff from Deloitte and those people about life cycles. And they're not quite like this yet, but used to be a life product went like that. And now it's more like that. And for more and more things. And the thing that really struck me was that pharma was beginning to move this way.
Yeah.
I'm sorry.
No, go ahead. I'm sorry. I had a point about pharma, but go ahead. Sorry, I didn't mean to interrupt. But
No, it just surprised me because I always think of pharma as being, and it's, hey, let's get a patent and let's get a continuation on it, and let's change the name of it to whatever plus, or what, or the new
yeah,
version of this. But I was surprised because I saw pharma's name start popping up in these Deloitte and these other McKinsey, these other reports analyzing the need for quick time to market and the fact that products were having shorter life cycles, in part because better products were coming along more quickly. But
Yeah.
I'm sorry, what was your
No,
idea?
we've been watching this COVID, vaccine battle play out, and maybe that's one example of it. We don't know how it's going to end up, but I mean, I was intrigued to learn that, for the Spanish influenza, the influenza of 1918 to 1919, that I think this is accurate, that no vaccine was actually created until the 1930s or 1940s,
I
right?
think,
And imagine if somebody was campaigning on that now. I mean, saying, we won't have a vaccine for COVID-19 for another 20, 30 years.
well, I think
And I guess, I'm sorry, go ahead. Yeah.
no, didn't they get the genetic sequence out like in weeks back in
Yeah.
January or
I,
whenever it was?
I think that's right. I think that's right. I mean, they've been doing. I mean, the big battle is the diagnostics move pretty quickly, and I think they're even talking about not a home kit. There might be a home diagnostic kit, but certainly one that they're thinking of using at the airports
See now,
pretty
and
pretty
my,
quickly. So
I don't know this, but my guess is that that's all driven by big data and
yeah,
AI.
yeah, and right, and be able to process the data quickly, and that's right. That's something to investigate. But I'm not. And I think even the polio vaccine. I mean, that we didn't really have an effective polio vaccine until the 50s, and that
Yeah,
was you know
I just think
40 years plus of suffering for that.
does it so we get to be the ones who test out whether AI is working very well.
Well, I mean, we're always the guinea pigs. I mean, we'll see how that works with the FDA. I mean, that's another dimension of this, right? In
Yeah.
terms of how this is going to affect the efficacy and safety tests as
Well,
well. So
that's an interesting question, though. So the FDA is going to be put in a position of assessing how well this data was vetted through all these systems, which probably they won't have very good transparency into. I mean, they'll understand the data, they'll get it, but how well was it processed in these algorithms? What was looked at? I mean, that's going to be a black box to some extent.
yeah,
Anyway,
I'm a,
that's
you
very
know,
thoughtful.
again, I think I'm a bit more optimistic than you are about this because I assume the FDA. I mean, I know again, no comment on the current administration, but in general, I think the FDA does keep up and tries to base it on science, at current science. Correct.
Yeah, but
So
it is an interesting question, though, and I assume they'll have the same access to the tools to assess the data as the presenters of the data, the vaccine makers do. But it
yeah,
is a weird thing because they're going to be assessing a vaccine in record time,
right.
relying on tools that have never been used before, at least to this extent, to substantiate the claims of the manufacturer. So
Yeah, yeah.
yeah, I hope it's all. I mean, and
Yeah,
I'm
I
like
mean,
you. I have very good faith in
yeah,
those agencies because of past performance. But it
right,
still scares the the speed at which we are proceeding still scares me. But it may be that we're
yeah,
proceeding at the speed that AI now allows us to do.
right. I'm
So
worried more about the politics than the underlying science. That's another issue. That's another podcast.
oh come on, yeah, I was gonna say, no, let's not go there. Let's not go there.
Yeah, yeah,
So, but that's the thing though. All of these same things then allow the accused infringer to get their product to market more quickly, right? They can look at and use 3D printing. They can use
sure.
artificial intelligence. They can, and this is a graph from, I think, Deloitte. And for those people who are listening who are young, I mean, I remember I bought an Apple. They called them Blackbirds. They were a laptop back in the early '90s, and I
Mm,
had a 40 meg hard drive, and I thought I was just killing it. And
right,
I think I paid $4 grand for that thing. And today, I mean, I've got an iPhone. What is this, 64 gigabytes or something
right.
like that?
Yeah,
And it was whatever, $800. I mean, I didn't buy it actually. I rented it or whatever. But the speed and like internet, we finally have fiber in my neighborhood, and I'm trying to get it put in. And I mean, I was looking at the speeds of it compared to what I have now, and the cost is lower than what
hmm,
I have now, and it's like 10 megs, and this is going to be like 1 gigabit, and it's
right,
cheaper.
right,
I
right.
mean, that's just breathtaking. And all these things, storage, and this is what allows this pace of change to occur. But
Hmm.
then look where we are with patenting. This is the total pendency from last month, and they're just under 2 years.
Yeah.
for the average total traditional pendency, regular applications and whatnot. So think about it. We got these product times shortening, infringer shortening. Patenting is shortened. I mean, it used to be 3 years. They've got it down to 2. But now what happens once you get a patent out? You get 2 years, you get the patent issued, and then if you're unlucky, you're going to get an IPR, you're going to get a stay, you're going to get 18 months of delay, more or less. If some claims survive, you're going to get restart litigation. And this is where this is going to start mattering. If the patentee prevails at trial and wins, and they only get past damages, which is, of course, what's more likely to happen now than eBay,
Mm-hmm.
they're only, and if the product's life cycle is over, that is the end of the story.
Right.
So your client needs to understand that if you do get a patent, it's going to be 3 years later, more or less, that they get out and they finally are able to obtain a money damages for past damages. And they're going to say, well, my product, 3 years is way past when this product or an accused infringer's product may be on the market. Do I really want to go for a patent under that circumstance?
Yeah.
The patent give me what I want.
And I'll put a plug in. This was your previous webcast for us, I think 2 or 3 years ago, right?
Oh yeah, yeah, yeah. And then these are real quickly just the things to think about with short life cycles. You know, is patenting the best option? Then again, I was a litigator. I still am a litigator. So to me, it's the reason why you get a patent is to sue people. I realize they have other things, they have venture capital, other reasons to get patents, defensive use, stuff like that. But if it's offensive use, they need to think about it. Using track one, which is a way to speed up prosecution radically within the patent office. Track one, somebody told me they got a case issued within 6 weeks. So it's cost, wow. Yeah, it costs you like $2,500 or something, and there's a limited number of them. But I mean, it is fast. And I mean, very, very fast if you can use track one. The other thing is, and this is hard to do, there's a way you can get damages under section 154D. Basically, as long as your claim doesn't substantially change from the date of publication till issuance, you can get damage from the date the application was publication. But if it's changed much, you're not going to get this option. But maybe you can do one claim that doesn't change and then fiddle around with your dependent claims.
Mm-hmm.
Possible option, to get an earlier 18 months as opposed to 24 months when your issuance occurs. The other thing, and this is, whether you can slow down competitors. If somebody else is seeking to patent, there's ways to do third-party submissions. Obviously, there's I forget what it is, a 1-year deadline. But also you can do what people call sometimes poor man's re-ex. You send to your competitor some information and you say, I see that you're getting a notice of allowance. Here's some really important prior art information that I'm sure you'll want to disclose to the examiner in your case. Mm-hmm. And it puts the competitor in a box of, do I disclose this stuff or not? And if they disclose it, chances are they're going to have to file an RCE and take the case out of prosecution and delay prosecution. There's a thing called CUPIDS, which I forget what it stands for. It's a patent office process where after you get your notice of allowance, if you receive additional information, you could submit it to the office. And effectively what you do is you file a conditional RCE and you pay the fee. And if the office will look at the information you disclose, and if they decide it's not material, doesn't raise any new questions, they'll issue the case and they'll give you your money back. If they decide that it does raise some issues and they need further examination, then they take your money and you go continue prosecution. But it's a way to potentially avoid it if you get stuff dumped on you. So this is a way to slow things down. If somebody does it for you, it's a way to speed things back up, is using CUPIDS. And people I know have used it have had very good luck, because examiners, a lot of times they're ready to issue a case and they'll look at the stuff and say, this is cumulative, I know what this stuff is, and they allow the case, and the case or they deny they allow the case, I guess, the simple way to put it.
Yeah.
We've only got a few minutes left, but let me just talk real briefly about 3D printers. Because of all of these things, because of increasing processing power, the bandwidth, these exponentially decreasing costs, the power of computer-aided design, 3D printers are putting us what people have called the maker economy. We can all make what we want. these are available, by the way, at Lowe's, not here in Macon, sad to say, but you can order these. Amazon has them. There's a whole bunch of these things. They're like $300 for decent ones and a little bit more for more expensive ones. They use plastic to print. Nowadays, though, they can print with using many more things.
Right.
But you can print all kinds of fun stuff with them. You can print toys and phone cases, guns, guitars, pipes, helicopter parts. Those are now regulated, thankfully. You can't just print them at home and put them on your helicopter. Yeah, I was glad to know that.
Yeah.
Perfectly fitting clothes, not like my shirt, you can actually print it out to size you, and somehow it's fibers using that. Biological material, all of these things. And by the way, I want to register Cadster, figuring, Napster has already probably been taken. That could be the Cadster file.
Yeah, but Lucas Campbell gave us a talk. Lucas Osborne rather gave us a talk about this a couple of months ago. So
yeah,
I'll link to that. So yeah,
and these are the things that I went and looked on what you can print on one of these. It wasn't Cadster, it was some other 3D file storage thing. Okay, having a Lego that looks like that says the word Lego on it creates a trademark violation. I doubt it creates a patent violation anymore. I don't know. Little baby Yoda or whatever he's called, trademark problem there, maybe copyright, but clearly trademark issues. I went looking for, like, I have a Denon stereo and I thought, what if the plastic cover, the remote breaks and I want to buy a new one? I searched Denon and 44 different models, 44 different things came up of products to print. I have a pool, so I searched Polaris pool cleaner. It's this plastic thing that cleans the bottom of the pool. Parts break on that all the time. I could print them at home. Okay, now I don't know if there's a patent covering those products to this day. I have no idea. But those things are out there and people can push a button, download it, and print the part. And this is where Lucas and Tim
Holbrook, right.
And I'll be real quick on this because I know we're out of time, but okay, so there's this file server out there that's distributing files to people. Do they infringe if they download, or does the service induce or contribute to infringement? Inducement requires specific intent to induce, and so you're not going to have that with the file sharing service, and you're not going to have that with a 3D printer. They just simply don't have the knowledge. Contributory infringement requires no substantial non-infringing use. The file sharing system has all kinds of stuff that doesn't infringe. Probably most of those things I showed from Polaris and Denon don't. The printmaker, same thing, that you can print all kinds of things that don't infringe. What about direct infringement? Yeah, the consumer does. So you're going to sue every downloader like the music industry did. Tim and Lucas argued that the CAD file infringes.
Right.
And they said that they argued that when the site transfers a file, it's selling the claimed invention.
Yeah.
And this is what I said about that is the file is not the object.
Yeah.
And so what do you do? And this is my last slide. There are patents already that say the product of claim 1 printed by a 3D printer. The first one, the earliest one I saw was, of all things, a lacrosse stick head. I guess stick's the right word. So they had a fancy new lacrosse stick with a head printed by a 3D printer. That was a dependent claim. Think about other forms of protection. I don't know if you can copyright a CAD file. The other thing to think about,
we'll find out after Google versus Oracle, probably.
Well, that's true. That is true. That is true. Think about.
Or probably not.
Well, okay. I thought you were an optimist. You told me you're
all right. That's the end of the day.
So, but think, are there other things your client can do? I mean, do they need to put little holograms or something on there? It's not going to protect against IP, but so that people will know if they're buying legitimate helicopter parts, if they're buying real Denon products or Polaris pool products. Not so much, the IP side, but counterfeiting and quality control issues. I'll just point out, I know we're out of time, the last few slides go into some really deeper things about what does it mean to be a lawyer in these ages. The effect of all this raises up the level of the bottom. Everybody shepherdizes instantly now. So being a good shepherdizer isn't helping you. Everybody's going to be able to write patent applications using AI pretty soon, let's say. What are you going to value add? What are you going to do about your baby lawyers not getting that experience and having a gap in being good lawyers? How are firms going to deal with those things? far
Yeah.
more fundamental issues than what I've had time to talk about. But I've really enjoyed this. And
Yeah, no, thank you. This was great. I don't know if you can share your slides, but
yeah,
there's some really great pointers here, and I really appreciate your taking the time. We're going to have to maybe do a part two, maybe have you, Lucas, and Tim, and maybe some others to do a mini symposium on this, both the lawyering side and the 3D printing side. But thank you for taking the time on a busy day
oh,
to do
absolutely,
this, David. I really appreciate it, and
absolutely.
all the best to you during this time.
Yeah, same to you. Be good.
Yeah.